Hey everybody and welcome back. If you've been following our series, we have been interviewing Justice Chelameshwar, who retired from the Supreme Court of India, on a variety of topics. From what is it that is a must-have quality in a judiciary aspirant or a lawyer, to what are his favorite interview questions, to what does he think about judiciary as a career, and if young lawyers and law students should look at it as a career. If you haven't seen these videos, we highly recommend that you go back and watch these videos and then come back for the current video. In today's video, we asked him a whole lot of questions which we often get, which are often asked from judiciary aspirants, which is something that you might find edifying or interesting. So today we asked him on what are 5 must-know judgments or cases that every judiciary aspirant, that every law student, that every lawyer must know. What are the 5 judgments that every lawyer, law student or aspirant should know inside out? Then we asked him if there are any laws in the country that he thinks requires a change or requires updating. This is a common interview question which is asked to a lot of exam aspirants, that what is a law that you think needs to be changed. So we asked this question to Justice Chelameshwar and we highly recommend that you hear his answer. In addition to that, we asked a whole lot of questions. What is one quality that every lawyer or a judge must have? What is important for a lawyer to know? The details of the fact or the details of the law. And then we asked him to share any anecdote or experience that he might want to share with everybody watching. So without any further delay, let's get into the video. Make sure you subscribe to our channel for new videos, and if you have any questions, leave them in the comments.
I.C. Golaknath's case, which is overruled later. But to understand Keshwananda Bharati, the law as it existed prior to Keshwananda Bharati, and what was the background in which Keshwananda Bharati's case came, you must necessarily read Golaknath, I.C. Golaknath. Then undoubtedly, as on today, in the last 70 years, the most important pronouncement of the Supreme Court in the field of constitutional law is Keshwananda Bharati. That's a must. Next, I would think the second judge's case, 1993, Supreme Court Advocates on Record. Now, second judge's case, that is the third judgment. And if we ought to further examine the field of constitutional law, Menka Gandhi, 4. And fifth one is MPV Sundaramaiah. MPV Sundaramaiah deals with the interpretation of the entries of the 7th schedule. And for a student of constitutional law, it is a wonderfully structured judgment, and the very scheme of the constitution, distribution of legislative powers between the parliament and the state legislature. And these 5 I would recommend every student of constitutional law to read. See, a lot of these laws require updating. For example, when the Indian Penal Code was introduced to this country almost 150-60 years back, it provided for penalties of imprisonment and fine. Quite a good number of offences prescribed under the Indian Penal Code carry a penalty of both imprisonment and fine, or fine in different combination. But in all the cases, the prescription was average about 100 rupees or sometimes maximum 1000 rupees, which was an astronomical sum when the code was promulgated. But unfortunately, in the last 150 and odd years, that never underwent a revision. It requires a more realistic view of the matter. To impose a fine of 100 rupees on somebody who has committed an offence today would be simply ludicrous. But then the Parliament never thought it to look into these things. That's one thing. Well, there'll be many laws which require an upgrading, or some of them simply require a repeal. Politeness is a quality not only for lawyers and judges, not only before a lawyer. In life, politeness is an essential quality to maintain the social harmony. Whatever you want to say, you may be very firm in your view, but the manner of saying it should always be polite. You may have the most violent disagreement on principle, but the way you express it, it can't be violent. It should be measured, polite. There is no place for discourtesy to a fellow human being. The other human being may be a mighty human being with a great power, or a very humble person on the earth. In either case, is a fellow human being. Don't forget it. Be polite to him. Be courteous to him or her. Sorry, by habit I say him. Both. For a lawyer, both of them are equally important. But complete knowledge of the facts is essential. If I don't expect a 3-year-old at the bar to be as sure of law as Jamshedji Kanga or Nani Palkhiwala. It doesn't just come that way in 3 years. Well, barring exceptions, very rare exceptions, you occasionally come across a brilliant youngster, that 1 in a million. But facts, they have no excuse because they are given a brief. They must read the brief. Understanding law requires a lot of other things, long years of study. Well, I can give you a particular incident, and actually it's about a case. There was a partition suit back in Andhra Pradesh when I was a peonage judge in Andhra Pradesh High Court. A partition suit, there are four or five defendants, joint family property partition, Hindu joint family, because these things may get. Now, one of the defendants died during the pendency of the suit. He was unmarried. The defendant was an unmarried person. So he executed a will bequeathing his undivided interest in the joint family property in favor of some nephew or some niece or somebody, or both. He executed a will. The legatees filed an application praying that they be brought on record for the death of the defendant, praying that they may be brought on record as the legal heirs of the deceased. It was very fiercely resisted. Every possible objection was taken, saying that the will is fabricated, the appropriate stamp duty is not there. You can imagine the number of objections that can be raised by lawyers in this matter. And one of the objections was, which stuck ultimately, that during the pendency of the civil suit, the deceased defendant could not have executed a will without the permission of the court. That was the objection taken. It's a matter of record, which found favor with the trial court, and the application was dismissed. The matter came before the High Court by way of revision, I think, or an appealable order, I don't remember now. Anyway, whatever it is, it came before the court. A very senior lawyer had appeared before me for the petitioners, the losing party in the trial court. The man was virtually in tears, but that this learned judge has propounded an astounding proposition, saying that. Then I told the lawyer, Mr. So-and-so, feel happy. The learned judge didn't say that the defendant could not have died without the permission of the court during the pendency of the case. I don't think I can have anything more hilarious than this.